Hey there, and welcome to The Explainer. I'm absolutely thrilled you're joining us today. Look, we're tackling a situation right out of the gate that is incredibly frustrating, but honestly all too common. You do the work, you put in the hours, and then you don't get paid. If you live or work in Texas, trying to navigate the legal bureaucracy to get your hard-earned money back can feel like wandering through a maze completely blindfolded. But you know what? That stops today. Our main goal for this explainer is to completely demystify the two most accessible, self-directed paths for recovering unpaid funds in the Lone Star State. You absolutely do not need a law degree to understand this stuff. You really just need the right roadmap. Speaking of roadmaps, here's what we're looking at today. Number 1, the economic barrier to justice. 2, the Texas payday law. 3, navigating strict TWC appeals. 4, Texas small claims court. And finally, 5, choosing your recovery path. All right, let's jump right into Section 1, the economic barrier to justice.
Let's just go ahead and address the elephant in the room with a scenario I think we can all relate to. Imagine you do a fantastic job for a client or maybe an employer, and they short you, say $5,000. Rightfully so, you're angry. You want justice, so you call up a lawyer. But then, the lawyer drops a bomb and tells you they need a $5,000 retainer just to take the case. The math simply does not work, right? Traditional lawsuits for relatively small amounts are functionally pointless because the cost of recovery completely wipes out the actual recovery itself.
The Silberman law firm actually hit the nail on the head with this quote. One of the most frustrating hurdles in the legal system is the economic barrier to entry. It's so true. High-priced attorneys frequently lock everyday hardworking people out of getting their money back. But thankfully, the state of Texas has recognized this massive gap. So rather than just throwing your hands up and giving up, you actually have two highly accessible self-represented solutions where you can fight for your own money without needing a lawyer on a massive retainer. Let's look at the first one.
Moving on to Section 2, the Texas payday law.
So this is your first major fork in the road. The administrative route managed by the Wage and Hour Department of the Texas Workforce Commission, or the TWC for short. Now, the very first thing the TWC is going to look at is your classification, because the protections of the Texas payday law, they exclusively apply to employees, not independent contractors. And here is the absolutely crucial point. The commission literally does not care what your written contract says. They don't care if your boss stamped independent contractor on your file just to save a few bucks on taxes. What they actually care about is the core philosophy of control. Did the employer have directional and operational control over how you worked? Or did you have complete autonomy and independence?
Now, what's really interesting about this slide is how the TWC proves this level of control. They use this 20-factor test. It's kind of like a giant puzzle. Let's break down 3 specific pieces of that puzzle. First up, work hours. If the firm sets a rigid, mandatory schedule you have to follow, you're leaning heavily towards being an employee. But if you control your own schedule, you look much more like a contractor. Next, look at tools. Does the firm hand you your laptop and software, or are you bringing your own specialized gear to the job? And finally, exclusivity is a huge one. Are you explicitly prohibited from working for competitors, or do you have a whole roster of multiple clients? Basically, if the facts show you're acting like an employee, you have the standing to use this TWC process.
Okay, so if you are an employee, Chapter 61 of the Texas Labor Code kicks in, and it has some incredibly strict rules about final paychecks. If you're fired, laid off, or otherwise involuntarily separated, your employer legally owes you your final pay within exactly 6 calendar days. 6 days! If you quit voluntarily, well, it's due on the next regularly scheduled payday. And a really important note here. Actually, a vital one. It is entirely illegal for an employer to hold your final paycheck hostage just to force you to return a company laptop or office keys. They can't do it unless they have a very specific prior written authorization from you allowing that deduction. Listen, here is where you absolutely have to pay close attention, because the TWC operates on extreme urgency. To use this free administrative process, you have exactly 180 days to file your claim from the exact date those wages were originally due. If you miss that window by literally one single day, the TWC cannot help you. It's a hard stop. Once you do file, the employer has a mere 14 days to respond. Fast, right? After the investigator looks at both sides, they'll issue what's called a preliminary wage determination order. And if either side disagrees with that order, they have exactly 21 days to file an appeal. The clock is always ticking here.
All right, let's head into Section 3, navigating strict TWC appeals.
So what happens when that initial ruling gets challenged? Well, it builds this 3-tiered ladder. Step 1 is the appeal tribunal. Now, this is an informal, de novo telephone hearing. De novo basically just means you get a completely fresh start. You swear an oath, present your documents, and you can even cross-examine witnesses right over the phone. If things don't go your way there, you can move up to Step 2, which is a review by the 3-member commission in Austin. But keep in mind, they don't hold a brand new hearing. They are just reviewing the recorded record of your previous phone call. Finally, Step 3 escalates into the formal judicial system where you can file a motion for rehearing or take the whole shebang to a state civil court.
Now, say you win your TWC claim, but the employer still just straight up refuses to pay. How do you actually get your money? Remember, the TWC doesn't just hand you a check out of a public fund. Instead, they act as your personal collection agent. And let me tell you, they have some very sharp teeth. They can place administrative liens on the employer's real estate and property. They can slap them with up to $1,000 in bad faith penalties. They can force the business to post mandatory payment bonds just to keep their doors open. And get this, if the employer hired you with the absolute intention of never paying you in the first place, it can actually escalate to a third-degree felony for theft of service. No joke.
Moving right along to Section 4, Texas Small Claims Court.
But what if you missed that strict 180-day deadline? Or what if you're a true independent contractor? Well, your alternative path is the Justice of the Peace Court, or JP Court. And the absolute most vital number you need to know here is $20,000. Thanks to some recent law changes, the JP Court has a massive jurisdictional limit. So if your unpaid debt is $20,000 or less, you can march right in and file your lawsuit right here in Small Claims Court.
And this brilliantly illustrates why, if you don't have a lawyer, you really want to stay in JP Court. It's essentially designed from the ground up as the people's court. The super strict rules of evidence, they're heavily relaxed here. Honestly, it feels a lot more like a televised court show. You stand at a podium, you present your printed emails and contracts, and you simply tell the judge your side of the story. Higher courts like your county or district courts are completely different beasts altogether. Up there, corporate lawyers will absolutely weaponize strict rules of hearsay and document authentication against you. Without a law degree, you run the risk of getting your case thrown out before you even get to clear your throat.
So, Small Claims Court is highly pro se, which just means self-represented friendly. The filing fees are incredibly low, usually just between $54 and $75. You can sue for the principal amount plus any interest, right up to that $20,000 limit. However, you absolutely must be aware of something called claim splitting. You literally cannot take a $30,000 debt and chop it into two $15,000 lawsuits just to sneak under the JP Court limit. No way, that's strictly prohibited. You either have to waive the extra $10,000 or take your chances in a higher court. Oh, and the biggest downside? If you win, the judge doesn't collect the money for you. The claimant, that's you, is solely responsible for actually enforcing the judgment yourself through things like garnishments or property executions.
Just as a really quick aside for anyone working in the trades, if you are doing construction, remodeling, or demolition, you have a highly specialized, fast-acting alternative called a mechanics lien. This is an incredibly powerful statutory tool that lets you secure unpaid wages by filing a legal interest directly against the physical property you just worked on. It legally binds the property owner to the debt, even if that sketchy contractor who originally hired you completely disappeared into thin air. But fair warning, you have to move lightning fast. These liens often require action within just 30 days of completing the work.
And finally, Section 5. Choosing your recovery path. Okay, now that we've outlined the two main avenues, how do you actually decide which one to use? Well, let's break it down. If you're an employee and it's been less than 180 days, the TWC route is fantastic. I mean, it costs you absolutely nothing, there is no statutory cap on the wage amount you can claim, and the state acts as your very own collection agency if you win. But you absolutely must obey their rigid administrative deadlines. Now, on the flip side, if you are an independent contractor, or say it's been a whole year since you were supposed to be paid, or if the debt is under that $20,000 mark, the small claims route is totally your champion. Anyone can file. The evidence rules use a super relaxed narrative format, and you can just honestly stand there and tell your story to the judge.
Look, knowledge is really only useful if you know how to apply it, right? You are no longer locked out by the economic barriers of high-priced lawyers. You have the Texas Workforce Commission on one side, and you have the Justice of the Peace Courts on the other. So I want to leave you with this question to ponder today. If you were wronged by an employer or client today, looking at the exact facts of your specific situation, which path gives you the most power to reclaim what is rightfully yours? Assess your options, gather up those documents, and never, ever walk away empty-handed. Thanks so much for joining me on this explainer, and keep learning.